She woke up, she was mad. During the fight, he broke her phone. Subsequently, he went out to the car, she followed him out. That's where the altercation occurred. And when she was leaving after she had kicked him, that he struck her.
But she was the one who tried to leave the scene, and he pursued her and used his size and strength to his advantage. The defendant has been in jail 8 times, prison 1 time, probation 6 times.
I mean, I don't disagree with the prosecutor that I think given your history, Mr. Coggins, you probably deserve prison. People v. Wilbert Coggins. It's file 25-7109FH. Counsel, you want to state your appearances, please?
What kind of prosecutor?
Daniel Hartman on behalf of Mr. Coggins.
All right, good afternoon, and we're here for sentencing on interfering with electronic communications, habitual third with a 4-year maximum, and domestic violence, 93-day misdemeanor, advisory guidelines at 0 to 16 months. Have you had a chance to review that report with your client?
Yes, we have, Your Honor.
Any additions, corrections?
No, Your Honor.
Any scoring challenges?
No, Your Honor.
Ms. Goodrich, any additions, corrections, or scoring challenges from the people?
No, Your Honor.
Mr. Hartman, go ahead with anything you want to say in your client's behalf.
Your Honor, the first thing I want to point out is that as the court could see, the agent did a good job of putting in both versions of the event of what occurred. Mr. Coggins pled guilty. He admitted what he did wrong, but he also, there are some mitigating factors in his story that are important, including the sequencing of the phone and the fact that even though she had kicked him and that when he struck her was after the kick, it wasn't in self-defense and it was wrong. That's how he pled guilty. And I submit, Your Honor, that this is a circumstance where he has a horrible history. He is a great employee. He's got a lot of support in the community. He is supported here today. And what occurred on the morning of for Mr. Coggins is she woke up, she was mad. During the fight, he broke her phone. Subsequently, he went out to the car, she followed him out. That's where the altercation occurred. And when she was leaving after she had kicked him, that he struck her. Mr. Coggins had asked me this morning to let the court know that he knows what he did was wrong. He knows it's a crime and he knows there's no excuse. And Your Honor, I think a lot of this was taken into account in the negotiated resolution of the case. I would ask the court to look at the circumstances of what occurred, and we understand that he is going to go to jail today. He is prepared for that. Your Honor, I don't know what the court's work release plan is or program, or if he's eligible for any other programming. And we would ask the court to consider imposing a county jail sentence as recommended, and the court to review the term. Obviously, Your Honor, we know that he's going to get the 93 days on the domestic violence. And this is his first conviction related to a telephone communication device. And Your Honor, the circumstances of this case are such that the parties have now separated. They no longer reside together. There was a period of time while he's been on bond in which he has had 0 infractions. He's been gainfully employed. He's been working. I know he submitted a packet to the jail for work release, and there is some indication that the jail may not allow work release because of the assaultive nature of the crime, at least during the first 93 days. And I would ask the court to recognize, we recognize his behavior was unacceptable. There was some provocative circumstances that don't mitigate his bad choice and don't address his criminal behavior. But I do ask the court to give him the maximum on the domestic violence and to set an appropriate sentence on the first phone charge, Your Honor.
Thank you, Mr. Hartman. Mr. Coggins, it's not required that you would make a statement here today, but it is allowed. Is there anything you want to tell me, sir?
Yes, I'm very sorry for what happened. I feel bad and horrible. I know things shouldn't happen the way they did, but I'm going to move on with life and be better.
Okay, thank you. Thank you, Mr. Coggins. Mr. Hartman, if you could please go back to the table.
Oh, I apologize, Your Honor.
That's fine, so that the prosecutor can be seen to make the statement. All right, Ms. Goodrich, any recommendations from the
Thank you, Your Honor. We are here because on October 20th of 2025, the defendant hit the victim, causing a visible cut and bump on her head. When she arrived to work that day, a co-worker called 911 for her. When law enforcement arrived, she was visibly shaking and crying. She had believed that she had lost consciousness after the punch in the back of her head that knocked her to the ground. The defendant had also broke her cell phone. I believe that the victim was honest about with law enforcement about some of the back and forth interactions between her and the defendant that day. But she was the one who tried to leave the scene, and he pursued her and used his size and strength to his advantage. The defendant is 45 years old. He was 14 at the time of his first arrest. He has 2 felonies and 14 misdemeanors and quite an significant assaultive history. We have the 1994 assault, the 1994 assault, 1995 assault, 1997 assault, 1998 assault, 2 of them that year, 2000 domestic violence, 2001 assault, 2002 resisting, obstructing, assaulting law enforcement, 2003 domestic violence, 2017 2 counts of domestic violence, and 2018 a domestic violence third. And here we are again in 2025 on a domestic violence charge with interfering with electronic communications. The defendant has been in jail 8 times, prison 1 time, probation 6 times. The guidelines are 0 to 16, giving the opportunity for the court to sentence him locally or send him to prison. The PSI recommendation is for local time at 12 months with credit for 3 days. Given his criminal history, I ask the court to do top end of the guidelines. Thank you.
Thank you. Mr. Coggins, you're 45, you've got prior felony history and extensive misdemeanor history, and as the prosecutor outlined, a fairly extensive assaultive history. The agent that prepared the pre-sentence report said this is the 6th time you've been convicted for a domestic assault. In 2018, you went to prison for one, and that makes it hard that here that there is, as acknowledged by you, your attorney, and the prosecutor, there was some physical interaction between you and the complaining witness. That certainly is a mitigating factor, but also then, she's trying to leave the situation and you're pursuing her and striking her. And I guess nobody's provided me with a criminal history of the victim, which would be highly unusual. But, my guess would be that she doesn't have 5 prior convictions for domestic assault. Yeah. I don't know. I mean, the tricky thing too here is, the domestic violence, if you've been convicted of a domestic violence third, we're on an E grid, a class E felony, and you would almost certainly have a prison outcome from that. The charge bargain to the interfering with electronic communications, even preserving the habitual notice, that's a class H crime. So I'm looking at an intermediate sanction cell, which has me start off from a position of a presumption of no jail at all, unless there's reasonable grounds for incarceration. I think there are reasonable grounds for incarceration in this case, as outlined in the pre-sentence report. Continued history of assault on domestic partners, the extensive assaultive history. And even though the criminal history is taken into account, it doesn't adequately take into account the similarity of that criminal history. So there's certainly grounds for incarceration, but really with it being an H grid, the case is pled down to an H grid with an intermediate sanction cell, so that for me to sentence you to prison, Mr. Coggins, would be for me to go on the top end of those guidelines, which would not take into account any of the mitigating factors, which I don't think they're as mitigating as you think they are, but there's some mitigating factor there. So it's tough for me to see how on a 0 to 16, I can give you 16. So taking all those things into account, I don't disagree with the prosecutor that I think given your history, Mr. Coggins, you probably deserve prison, but I got to be able to find something here that I got to follow the law of the Michigan sentencing guidelines and the recent laws about intermediate sanctions as well. Taking all those things into account, there's $118 in state cost, $130 in a crime victims assessment, and court costs of $350. On the domestic violence charge, I'll order you serve 93 days jail with credit for 3 days previously served. And on the interfering with electronic communications habitual third, I'll order that you serve 12 months in the Sheboygan County Jail, give you credit for 3 days previously served. I'm not going to allow you any work release program, but I will allow you to participate in cognitive behavioral therapy in the jail if you qualify for that, and you can earn a little bit of time off your sentence that way. In any event, that's the sentence of the court. It's within the advisory guidelines. I think I have placed on the record my reasons for incarceration despite the 0 in those guidelines. If you want to appeal, you can file an application to the Court of Appeals. If you want a lawyer appointed, you'd have to ask within 6 months. We're going to hand you a piece of paper explaining that, ask you to initial 1 copy for us, and the other one is for you to fill out if you want to take an appeal. Do you have any questions for me, Mr. Coggins?
No, sir.
Okay, you're not on probation to me, so once you're done with that sentence, you're not on paper. Okay.
Your Honor, apologize about late, it's a 3-hour drive.
Okay. Oh, that's right. I forget that you're not up here anymore.
Yeah,
Okay, well, good to see you.
thank you, sir.
She's trying to leave the situation and you're pursuing her and striking her. And